there are two phases of Article 10. There's a pre-application phase and an application phase. I'd like to talk about intervenor funding during both of those phases. I'm going to explain who is eligible, as well as answer some questions about the process. And then at the end, I think as Maz mentioned, we're going to devote a little bit of time for you to ask project-specific questions, but at least initially I'd like to focus it all on the intervenor funding process, and then we'll take it from there to basically project-specific questions. So the background, why do we have intervenor funding? We have intervenor funding to help foster public involvement and participation. What it basically allows you to do is to, qualifying recipients are going to be able to hire experts and lawyers to assist in pre-application activities as well as application review. This is different than the old Article 10 process. Legal counsel was not an authorized expenditure in the old Article 10. That changed in this new Article 10 process. Intervenor. What is an intervenor? It's basically anybody other than the applicant who is seeking to join in the case as a third party for the protection of an interest. To give you some context, so there's as I mentioned before, a pre-application phase and an application phase. We're headed towards the pre-application phase where Vincent Wind Farm will submit a preliminary scoping statement. Now, this is a document that will contain a wealth of information. I've listed some of it here. I'm not going to rehash it all, but this is the type of information that's going to be in the preliminary scoping statement. This information is also included in the preliminary scoping statement. So there's going to be a lot of information that comes out when we file the preliminary scoping statement. And the intervenor funding is there during the pre-application process to assist in the review of all this information that's going to be coming down the pipe. So, eligibility. All municipal and local parties are eligible, and at least 50% of the intervenor funding is going to be dedicated to municipalities. What's a local party? A person residing in a community who may be affected by the proposed facility. It's a very, very broad category. Municipality, again, very broad. It's exactly what you would think it would be: county, city, town, or village. What can the money be used for? So it can be used to defray pre-application expenses incurred by a municipality or a local party, for expert witnesses, consultants, and administrative costs, as well as legal fees. Just one distinction: you can't use it for judicial review or litigation costs. So you can't apply for intervenor funding and then seek to use that money to go sue the applicant or sue the municipality. So what's going to happen here? We're going to file a preliminary scoping statement, and a presiding examiner is going to be designated by the Article 10 Citing Board. That's essentially an administrative law judge that's going to be appointed to oversee the Article 10 application process. As we file the preliminary scoping statement, there will also be a notice published by the applicant, by Cape Vincent Wind Farm. They'll publish that notice, and it will contain a summary of the preliminary scoping statement. It'll also let the general public know that the intervenor funding is available. The next thing that's going to happen is the presiding examiner is also going to issue a notice of availability of intervenor funding. that notice is going to be more detailed with respect to the intervenor funding process, a schedule, and hopefully a form of application will be forthcoming with that notice, if not sooner. We believe that the Department of Public Service actually may issue an application or a form of application well in advance of any filing of the preliminary scoping statement. Once that notice and schedule is issued by the presiding examiner, applicants for intervenor funding are going to have 30 days within which to apply for that money. Requests for applications for intervenor funding will be submitted to the presiding examiner, to other parties in the proceeding, as well as the secretary of the Article 10 Citing Board. Then at least 45 days and no more than 60 days after the PSS is filed, preliminary scoping statement is filed, the presiding examiner is going to convene a conference of applicants for intervenor funding, at which point in time he's going to consider, he or she will consider requests for funding. And you're at that juncture, any applicant's going to be expected to be at that proceeding and be able to answer questions regarding their application. I think I skipped a slide here. We can just go back to this. How much money are we talking about here? So with the filing of the preliminary scoping statement, we would expect that there'll be between $70,000 and $99,750. So approximately $100,000 if the application is for a 285 megawatt project. And that's just some math on how it's calculated if you're interested. Okay, so what needs to be in the application for intervenor funding? The number of persons represented and the nature of the interest represented. Other resources and funds available to the intervenor applicant, as well as efforts to obtain such funds. Amount of funding sought, if relevant, the name and qualification of experts. Details, can't stress enough details. Details regarding services to be provided, hourly fee or wage rate, as well as expenses. Finally, two final really important items. How will this consultant or expert or counsel help to add some measure of productivity to the ultimate record? That's going to be something I can't stress enough, that you're going to need to justify why this money is going to be spent in the manner you're asking for it to be spent. And then finally, a contract. As I'll get to later on with some examples, having a contract in place is going to be crucially important to the presiding examiner when they review your request for intervenor funding. If the purpose of the intervenor funding is to undertake a study, these are items that you're going to want to articulate in your application as to why you're asking for the money. You're going to need the purpose of the study, the methodology of the study, the timing, rationale, a detailed justification for the study, a basis for the independent study, and efforts made to get the Article 10 applicant to undertake the study on their own behalf. So what will the presiding examiner do? So the presiding examiner obviously is going to have to set aside, if we use $100,000 as a round number for the pre-application phase, $50,000 of that money would be set aside for the municipal parties. The rest would be available for everyone. The presiding examiner is going to try and allocate that money on an equitable basis among the various applicants that are applying for the money. The rationale that the presiding examiner will use in allocating the money will be who's going to make an effective contribution to the review of the preliminary scoping statement and thereby provide early and effective public involvement. Two other side points. Intervenors are going to be encouraged to consolidate requests. So if there are similar issues, similar interests among differing groups, they should band together and go after the money together. If two parties are looking to hire the same lawyer, same expert, same consultant, similar encouragement to go off and group together and pursue that money and pursue that activity together.